This lecture is an overview of survey standards, certifications, and non-plat work products. So most of the time, surveyors and the public associate land surveyors almost exclusively with property boundaries and plats. That's understandable. At least 90% or so of our work product as land surveyors fall in that general category. Subdivision plats, retracement surveys, ALTA surveys, they all fall under the heading of plats or boundary surveys. Standards have been created in almost every state, or perhaps every state, that dictate a minimum level of care that is to be demanded of surveyors in those states. And these standards can vary from state to state. Some of the variations are particular to the land division systems, such as Georgia is the only state I know of that has land lots. So you don't see the requirement in Arizona or Pennsylvania to show the land lots on a plat. Subsequently, Arizona is a USPLSS state, and Georgia is not. So in Georgia, you don't have a requirement to show a tie to a section corner or a township corner. So that's part of the reason for the variations from one state to the other. Others are where states have a generally higher regulatory atmosphere, and they want to be very detail oriented and make sure that professionals in their states, everything from accountants to nurses to funeral directors to land surveyors, have clear guidance and a lot of technical minutia on what is required. Other states are less regulatory and leave more freedom, more discretion to the professional. While that is good in some ways, that's also bad in others because it opens the door for varying levels of care in the same marketplace or region that are not producing the same work product, yet check the box, so to speak. So here we have just the caption of two states' standards of practice or state board rules. On the left here, this is from Tennessee, and this is just the header or the caption that tells what's going into it. And you can see they have a chapter on applicability, the general terms or the general provision, the definitions, an area that's reserved, accuracy for surveys, maps and mapping requirements, survey types, making boundaries, land descriptions, instruments, and GPS. So they're getting very detailed. Georgia, we've studied a lot of their rules. They don't have a similar table of contents and caption. We've studied a lot of their rules, and the Georgia rules are in the reading assignment for this week. So partly because of all these variations, starting in around the 1950s, as America's post-war real estate boom got going, title insurance became something that people hadn't thought about a whole lot. But more banks were loaning money on properties, more people were borrowing money to develop properties or to build houses. And so title insurance became pretty important. And so title insurance companies rose to meet the need. And they realized early on that they had to either become very astute in each state as to their surveying standards and what they were getting, and stay on top of the changes in those states, which, if you think about it, might not be that hard, but it's also it's pretty laborious, and especially in the 1950s, it would have been a lot more difficult than it is today, where anyone can get on the internet and go check state board websites and legislative websites in 50 states, but it still becomes pretty laborious. Some states, as we just said, have even then had pretty detailed expectations and requirements for surveys, while some states And as recently as 10 years ago, one state in the Northeast had virtually no technical standards whatsoever for surveys. So my interpretation when I was working on a project in that northeastern state was that basically surveyor could paste off a boundary, hand draw it on a paper bag, put his seal on it, and there was really nothing in that state's regulations that made that illegal, improper, or a violation of any kind. So that's an extreme example, but the title insurance companies realized this. The title insurance companies, like most trade organizations or groups, they formed an organization, a professional organization or a business association called the American Land Title Association. And of course that goes by the acronym ALTA, or as we commonly call it, ALTA. Now ALTA survives to this day and has grown and thrives and provides a lot of detailed specifications, not just for surveys, but for title examinations. And they offer all kinds of different specialty title insurance features, products, indemnifications, such as for operation of business. They will ensure if what you're doing is compliant with the city's building code or zoning code. And so if you get in trouble with the city, if you have that particular endorsement, which does cost a lot extra and require a lot of extra work, ALTA's policy, or the title insurance company's ALTA policy, will come defend you for that. Otherwise, it's just a standard title insurance policy. And it doesn't have to be an ALTA survey or a multi-million-dollar piece of real estate. Most any title insurance policy, even on a rural small tract of land, even if it's written by Podunk Title Insurance Company or the local title office, is still going to follow ALTA guidelines, at least in general. So anyway, ALTA figured out in the 50s that they didn't feel all that comfortable going from a state to where a paste off survey on a paper bag was legal to a state where specifications were laid out for surveys to the nearest tenth of a foot and bearings to the nearest minute, going back into the 1950s, and where things had to be done, corners had to be set. Not all states, not even Georgia, required that corners be set when subdividing land until just within the last few decades. So ALTA's looking at it from their standpoint of, we're going to be asked to issue a big title insurance policy. How do we cover ourselves? And it became pretty clear they needed a national standard. They didn't need to know what the differences were in the state standards from Georgia to Pennsylvania to Minnesota to Oregon. They wanted to set a standards that if you certify that you're complying with those standards, then they know what they're getting. It's a gold standard. It doesn't matter what state you're doing it in. And even though these are not state standards that are enforceable by state law or by state boards, when a surveyor agrees to prepare an ALTA survey, that is a contractual matter. Surveyor may not realize it, but legally, this is the legal aspects course, legally the surveyor has just contractually obligated himself or herself to comply with the ALTA standards, which is part of the reading assignment. So that's how that comes into play. If a ALTA survey, just put it in plain terms, is boogered up, sure, the damaged party might file a state board complaint against your license. They might file a lawsuit saying that you violated this state code, you failed to uphold this standard of care. But one thing that makes an ALTA survey a little bit more prickly from a surveyor in regards to liability is you've made it a lot easier for a damaged party to come after you, because you have a contractual agreement to hold yourself to a higher standard. And if you didn't, it's pretty easily proven. It's black and white. It's probably not going to go to court. You're going to settle, or your professional liability policy is going to step in and say, no, this is our mistake, we'll pay you for your damages, make that go away, and then they come back at you. And they'll either drop your coverage or they may look for some restitution or all kinds of things there. But just know that an ALTA surveyor, anytime you make a particular certification, you're basically, whether if you realize it or not, crossing over into the realm of contract law, and you're making a written obligation to do something besides just uphold the state standards. So you don't have to worry about the state board coming after you. It's your client's attorney, and he has a clear kill shot if a mistake was made negligently. And there's more on that in the next course. Anyway, back at that time, the primary surveyors organization on a nationwide basis was the American Congress on Surveying and Mapping, ACSM. You'll see prior to 2011, these standards and surveys were called ALTA ACSM Land Title Surveys. Prior to 2011, ACSM and NSPS, the National Society for Professional Surveyors, which had basically become competing organizations, they merged and took the title NSPS. So starting with the 2011 ALTA standards, they're known as ALTA NSPS. So they were first adopted and issued. The initial ALTA ACSMs were adopted in 1962. They've been revised and updated 9 times since, and they're under a constant state of revision. Well, not really revision, but comments. And then every 5 years, an updated version is published and adopted. Now, I was personally involved in updating, or in the process to update the 2021 standards through COVID. That committee did not meet in person and hammer things out. It was all done by email and Zoom call. And I participated in that process, which was very enlightening as to why we have the ALTA standards the way they are and why the Table A standards are the way they are. And this will also be covered in much greater depth in professional practices. But for the purpose of this course, it's important to know how the legalities and how these pieces fit. So over here on the right is the caption from the ALTA NSPS Land Title Surveys. It says the purpose is the members of ALTA have specific needs unique to title insurance matters when asked to insure title to land without exception as to the many matters which might be discoverable from surveys and inspection and which are not evidenced by the public records. So that's why ALTA and NSPS create these. So the purpose is to be able to satisfy the survey exception in a title policy. But we will not examine in great detail any of these standards. It is part of the assignment, but the assignment for this module is not designed to go very deep. We're not looking for minute differences or how to comply with statistical analysis. Part of that's math and surveying science that you've already had. Part of that will be in the application part in professional practices next semester. Also want to mention that the ALTA standards, when they are reissued, the effective date is always February 23rd. This is because this is the date of the annual festival of the Roman god of boundaries, Terminus. The festival is Terminalia. This is kind of odd, but that's why they chose the date. So every state has some form of certification for boundary plats. ALTA NSPS Land Title Surveys has their own specific certification, which must be used verbatim. Now, I'm going to stop for a minute to talk about that because it's history for the most part now, but it's very important because we don't know what the future holds or what people will do. So prior to, I believe it was the 2011 ALTA standards that says the ALTA certification has to be made verbatim. Why is that important? The ALTA certification is a collaboration of a panel of highly recognized distinctive surveyors from around the country on the NSPS side, and an equally diverse and distinguished group of title attorneys on the ALTA side. So they've come together and decided this is what that certification needs to say. They don't want it to be weakened. Surveyors don't want it to be altered such a way as expands their liability. And I saw things in certifications that lenders and underwriters and clients will even submit that are basically preposterous, but they have demanded in the past that surveyors sign it, such as this property is in compliance with all state, local, and federal laws. Well, you might say that's okay if we're talking about the fact that it was legally created, that the building on it is within the setbacks, stormwater goes to approved stormwater management, MS4. There's all kinds of ways that you can rationalize that to make sense from a surveying standpoint. But what that certification says goes way beyond that. For example, what if it's an older building and there's lead paint or asbestos insulation in there? It's an EPA hazard, has to be mitigated, tore out, replaced. Well, the surveyor just certified that the property was in full compliance with all state, local, and federal laws. So guess what? The surveyor might be helping do an asbestos cleanup or a lead paint remediation. Yeah, that's crazy, but in the world of litigation and insurance claims, all the 1-800-FOR-THE-PEOPLE.com and all these things, anything is possible. You would be shocked to know what all surveyors have been sued for. There was a case in Northeast Georgia where in an industrial park, that certification had been applied. Basically, this is in compliance with all state, local, and federal laws. Come to find out, they were making and selling drugs out of the back of this warehouse. They had a legitimate business in the front. They had a refinancing, required an ALTA survey. The bank also wanted this particular language on there that it complied with all state, local, and federal laws. They got busted and shut down, so they filed suit against the city, the county, their insurance company for loss of business, loss of revenue coverage. They sued the surveyor because their attorney read the plat and realized that the surveyor had said that the property was in full compliance. So everybody was suing everybody, and when that happens, which is very commonplace, it's called the shotgun effect. You just fire a big old pattern of shotgun pellets at everybody involved and see who you hit. How does that come back into the surveyor's world is, well, everybody that gets named usually has to hire an attorney to represent them, and there's a big mass clearinghouse hearing, and this a preliminary hearing where all the parties get up and say, Your Honor, my client has no connection to this, he has no liability, he's not done anything, and the judge says, yep, you're right, you're dismissed. Now it went from 12 parties to 11. They go through that until they get down to only the parties that can't get out of it, the parties that actually have some skin in the game. Or in this case, the surveyor had made an absolute statement that the property was in compliance with all state, federal, and local laws. So because he had made that statement, he could not be dropped. He was potentially culpable or liable. My understanding is he settled for something like $15,000 plus whatever he paid his attorney's fees, and he learned a valuable lesson. Now, let's look at so Black's Law Dictionary says a certification is a written affirmation of a fact. So let's think about that. You're making a written statement as to a fact. So it needs to be a fact, not necessarily an opinion. In the professional world, our opinions are based on facts. So they kind of becomes a blurred line there. I've taken Georgia's State Board Rule on certifications to kind of illustrate what a certification is. Board Rule 180-6-.09, the term certification is, and relating to professional engineering or land surveying services, shall mean a signed statement based upon facts and knowledge known to the registrant and is not a guarantee or warranty, either expressed or implied. So basically, any statement that you make on a plat or in a report is a certification, even if it doesn't say certificate. Certification or certificate, where it's specifically labeled and brought out, that basically doesn't change anything, except you're making a distinct effort to say, yes, I am clearly certifying to this. Even though the board rule says that it is not a guarantee or warranty, either expressed or implied, words can be placed in that, and in certain contexts, the law may trump the board rule, and you may be expressing a guarantee or a warranty because you know people are going to be relying on it. So this is kind of the meat and potatoes. When an engineer or land surveyor is presented with a certificate to be signed or sealed, he or she should carefully evaluate that certification to determine if the certification A, relates to matters which are within the technical competence of the engineer or land surveyor, B, involves matters which are within the scope of services actually provided by the engineer or land surveyor, or C, relates to matters which were prepared under the supervision, direction, and control of the engineer or land surveyor. So basically, what does that mean? If you're a land surveyor and you don't have some special certification in asbestos or lead paint, then you should never make any kind of certification that would lead to making a statement about asbestos or lead paint. You can have different areas of competence within surveying. Someone who surveys around the coast and around sand dunes and tidal boundaries might not be all that competent about how things are done in the mountains, or vice versa. So you might be careful about what sort of things you certify something to, because it has to be within your technical competence. If you're a surveyor who uses a total station and a prism pole and draws lot surveys only, no problem with that, but probably should not make a certification about laser scanning or LiDAR and point cloud distribution and statistical analysis of inferred data, because that's outside of the technical competence. Someone might say, I need you to sign this certification, I'll give you $500. Don't take the bait. That's also, you need to be within the scope of services actually provided. So it gets into a different gray area if you're being asked to help look into violations or wrongdoing by another surveyor. You have to do enough work that you can speak to your work. And it has to be matters that you prepared or did, or that was under your supervision or direction. You don't need to be certifying that you're aware of what somebody else did if you didn't do it. It's a lot of common sense things, but just understand that's what a certification is. A little bit more on that later. So now we're going to be talking about the legal definition for standard surveying, because this relates to the difference between plats and non-plat work products. Sort of what we're talking about here. We've already studied this in one of the early modules. We want to look at the fact that A, measuring and locating lines, angles, elevations, natural man-made features, blah, 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 and for the purpose of determining and reporting positions, topography, areas, and volumes. All right. Does that say anything about plats? No. So does this include things that might not be a plat? Even though it's 90% of what surveyors do, yeah, this tells us that if we're doing all this, which requires special knowledge of the principles of mathematics, related physical and applied science, requirements of relevant law, and the evaluation and location of property rights as applied to these things. So this is what is in the legal definition of surveying. This is the work. This is the sort of work that requires a surveying license. Think about that. Section B. Yes, here's plats and boundaries. Establishing, reestablishing, locating, resetting, monumentation, property boundaries, boundary, blah, blah, blah. C, the platting and layout of lands and plats thereof, including alignment and grades of streets and roads. So this is not a plat that shows property lines necessarily. This is subdividing them. D, the plating, design, and layout incidental to subdivisions of any tract of land by a land surveyor of I, grading plans and site plans. Now, we're going to stop there for a minute because, you know, this is, I said I, it's little one. Little two, or double I, actually falls into a different legal category. The remainder, though, of the standard definition, and when I say standard definition, the standard surveying license issued by the state of Georgia and most other states authorizes licensees to perform basic land surveying, I won't say basic, but even very complicated land surveying traditional services like we're talking about. Not only plats, but also locating and establishing elevations and positions and things like that. In Georgia, we also have a section of law that land surveyors are allowed to practice in that are known as the hydrology and design authorization realm. And that's where the two I's, or the number two, little number two, comes into effect. We'll talk about that in just a moment. This is the rest of the standard definition of surveying. So if you go and do not take the hydrology and the fluid mechanics and those engineering courses and pass the optional hydrology exam, you will be a standard definition licensed surveyor, PLS. And you can do everything that's on the first slide and on this slide. If you do go ahead and take the hydrology coursework and pass the hydrology exam that Georgia administers, then you're allowed to practice in these HDA, or hydrology and design authorized services, which we'll cover. But so skipping past those, we come back to section E, conducting horizontal and vertical control surveys, layout or stakeout of proposed construction, or the preparation of as-built surveys, which relate to property easement or right-of-way boundaries. So layout of construction is not all within itself isolated to being a professional work product of a land surveyor. You can lay out property on your own site if you're a contractor or a homeowner. Within some limits, you can even do that as a service to others if you're not licensed, as long as it doesn't get near the boundary of any property line or easement. So that gets into setback compliances, and in a lot of ways that makes it to where most construction layout needs to be done by a surveyor. But if you're out in the middle of a 50-acre piece of property and you're trying to shoot grades and lay out light poles in a 2-acre parking lot, that's not going to require a licensed surveyor. Section F, utilization of measurement devices or systems such as aerial photogrammetry, geodetic positioning systems, land information systems, or other similar technology for evaluation or location of property easement or right-of-way boundaries. And finally, the preparation and perpetuation of maps, plats, drawings, records, reports, descriptions, field notes, etc. So the work product. So let's stop for a minute. We have a pretty good idea what a plat is, what needs to be on a plat. We'll study that in more depth in this module's assignment, but many people are very surprised to know that there are professional services that surveyors can provide, in many cases only surveyors can provide, which are not plats. They don't result in a signed boundary document or boundary plat that has to comply with Georgia, Tennessee, Texas, ALTA survey standards. So what are these? Well, here's a short but not inclusive list. There are a lot of other items that could be added to this list that are so rare that I didn't feel like they were really something to include. Topographic surveys. They often result in a map or a drawing, but not always, and they don't have to comply with the same technical standards that a property survey does. Often the topographic data is transmitted to another design professional as a CAD file electronically, and there is no actual drawing, paper or PDF. Similarly, aerial mapping and LiDAR. There are exceptions for non-surveyors to do this, but for the most part, this is a land surveying work product. There are field-only property engagements where you may be hired to just verify property corners or to mark a property line for a fence or for clearing or for a garden, and no plat or report is required. There's nothing in the law that says that if you go out and stake a property line that you have to survey the whole property and issue a plat or a drawing. Construction layout, we just talked about that. Many times it is surveying, but or within the legal definition, sometimes it's not. But if a surveyor does it, there's a higher level of responsibility because you hired a licensed professional. So there's the expectation that you're going to do a better job. Monitoring wells or geological features survey. So it's not uncommon, especially in western states, to have the face of a wall or a large leaning boulder checked precisely, periodically, every 3 months, every month, every year, to see how much it's moving, because there comes a point in time to where collapse or a rock slide becomes more likely or not. There are areas where similar to those geological features, some of the geological features are underground and they've drilled monitoring wells. And so these monitoring wells have the position of them, in state plane or in latitude, longitude, have to be reported to state and federal authorities to know exactly where they are. This has nothing to do with the property boundaries. They don't care if they're on the subject property or not. Sometimes the monitoring wells are on neighboring properties where contaminants are leaching through the subsoil and the water table. And so sometimes the water, the monitoring wells are on adjacent properties, and everybody knows it, but the property line's not important. No plat is produced. Similar to some of the geological features I was referring to, retaining walls, structures, and subsidence is monitored often. For example, there are areas in Louisiana where the ground is sinking, and when it gets to certain levels, buildings may become less inhabitable, and they may require additional shoring or reinforcement. There are various reasons that these minute movements need to be made known, but they are known. A lot of times survey targets are permanently attached to a boulder or to a post in one of these uncertain or settling pieces of land, and then a measurement is made from a stable, non-moving benchmark or control point, and that's reported that this building has moved, or this wall is now leaning an additional 13 thousandths of a foot over what it was last year. These are things that have nothing to do with property lines, but things that come up. BIM, the building information modeling, architects and other people do that. Sometimes they hire surveyors to do that. Sometimes they hire surveyors to do that because there are accuracy certifications that have to be made. Not all the time, but some of the time. Surveyors are the only people that are really legally in a position to certify accuracy of measurements. Laser scanning, not just inside a building, but laser scanning a bridge, an overpass, a building, a park. That's gathering three-dimensional geospatial data. Nobody's probably going to arrest an architect for doing that if they're about to design a park, or a landscape architect. But typically that's something that a land surveyor does because it has to be precise. It's not just turn it on and hope that the results work. There's quality control, surveying procedures that have to be followed. Totally changing gears, you have a lot of other things that are not this minute, but are everyday. Alcohol license surveys. In most cities and counties, if a business wants to apply for a license to sell alcohol, either bottled or by the drink, part of the application to the city or county for their alcohol license includes an alcohol license survey. And their ordinance is going to say, the establishment has to be a certain distance from a protected class of structures or uses. For example, might say that the front door of the establishment has to be at least 1,000 feet from a school, church, place of worship, park, or a rehab facility. And every alcohol ordinance that I've ever seen seems to be different. Sometimes it is the walking distance along the sidewalks and beside the streets that they look for. Sometimes it is a straight line measurement. Sometimes it's from the closest property corner of the establishment to the nearest property corner of a protected class. Sometimes it's from the building corner of the establishment to the nearest property corner or nearest building corner of a protected use. I personally will not perform these type surveys, not because I'm an abolitionist or against alcoholic consumption, but because of the professional side of it. There are many different interpretations for these, and prime example was a case that I was drug into as a consultant in Cobb County a few years ago, where a surveyor was being sued because he had issued an alcohol survey, and he had measured the nearest distance, or the distance to the nearest protected class was a school up on such and such a road. He did a fine job measuring it. The minimum was, I think, a quarter of a mile in this case, or 1,320 feet. It was like 2,000 feet. Measured it, made a nice little diagram. Well, as soon as the city issued the license, in a business park about 600 feet from the alcohol establishment was a business that opened its doors and allowed use of its facility on Sunday to a local congregation that had lost their church to a fire. And they had a sign out front that said, XYZ congregation meets here Sundays at 11. So 600 feet away was a church or a place of worship. It wasn't really a church. It was not a church building. The ordinance said place of worship. So that could even be construed to, if you decide to have prayer meeting in your home, is that a place of worship? It just opens the surveyor to a lot of exposure, and actually a lot of cities and counties have quit requiring them. They're doing them themselves by using GIS or QPublic measurements. And as a land surveyor, that's totally fine with me. I don't want the work, and I recommend that anybody that does it takes it very seriously and puts all kinds of qualifying languages on it. I did one time where the distance was 1,000 feet, and it was clear it was from the two nearest building corners, and I was 960 feet, and I told my client I can't do it. He went to the city. The city was very pro-business. The city wanted this business to be open, wanted to give them a pouring license, and I received instructions that were contrary to the city's ordinance, where they said, well, let's look at it as walking distance. If you go down the sidewalk and turn left, and then you have to go up and you cross the street, doesn't that make it longer? Makes it 1,010 feet. Use 1,010 feet. So I did it. I was directed to do so by the city, but I added a whole paragraph that the distance was not the straight line distance. The distance was a walking path distance as dictated by the city manager on February 23rd, 2015, blah, blah, blah. This, acceptance of this method is conditional on the city's approval, so that basically I was being upfront and telling the city, or telling whoever might subpoena that, might contest that later. They're not just going to go after the city, they're going to go after the surveyor that enabled the city to issue that permit. Moving on, elevation certificates and LOMA forms are forms that are not plats that FEMA puts out regarding floodplains for the purpose of floodplain management by building officials and building inspectors, and also for flood insurance. The new format does not require them for every flood insurance policy like they used to, But if a property owner is not happy with the premium, they are free to pay to have their own elevation certificate done. And if they qualify, a LOMA is a letter of map amendment where a property can be removed from a flood hazard area and the requirement for flood insurance. The Federal Aviation Administration requires 1A and 2C surveyor certifications for a lot of different things. Cell towers, runway approaches, there are all kinds of things that have nothing to do with property lines, but have everything to do with geodetic positions and elevations, because it's a three-dimensional thing that the FAA looks at. Volumetric surveys. I've prepared many of these to where for inventory purposes or for billing purposes, someone needs to know how much rock was taken out of the ground in a rock quarry, for example, or they've taken it out of the ground and they've stockpiled it into these huge piles that are hundreds of feet wide and sometimes hundreds of feet high. They need to know the volume of that. How many cubic feet of pea gravel, river stone, crushed aggregate, 57 stone, crusher run, whatever it is. They need to know the volume of it. And this is often to make sure that to calibrate their billing records, or to make sure that they have all of their stone accounted for within a certain percentage. Sometimes it's for regulatory reporting. We had, such a date we have this many cubic yards or cubic feet of this type of sand or this type of stone on hand. For some reasons, we may need to create positions and set geodetic control points or benchmarks. Might be for a very important construction project or for floodplain matters. Totally unrelated surveys are the forensic accident scene surveys. Rarely are those done by private surveyors now, because the State Patrol in Georgia and most other states have bought surveying equipment and do their own accident reconstruction surveys. But if it's contested and going to court, a lot of times an insurance company or one of these trial lawyers will hire a surveyor to do one, maybe to overturn or contest or compete with the State Patrol's accident scene survey. Who wins in that case? Well, private surveyor that's educated and licensed, or a state trooper who went to trooper school and then took maybe a 2 to 5 day class on how to do accident scenes. I don't know. One does them all the time, one doesn't. But these are things that we can get into. Whether if it's a property dispute or an accident scene, this can often turn into expert witness consulting, where you're not turning out a plat, you're either turning out a report or you're just testifying. That's not for a lot of people. A lot of people shudder at the thought of it. I'm one of the rare surveyors who actually enjoy that, and I do quite a bit of it. There's also setback verification forms and foundation letters that building departments require before concrete's poured or before you can proceed with home construction or building construction. Some counties require surveys. Some will let you buy or have their own form or a letter. And then there are tree surveys. People may want to know what kind of trees they have and where they are for. Maybe they're going to build a house or a building in there, and they want to know where they are so they can situate the house, either to miss them or they at least know which trees they're taking down as they make those decisions. So there are all kinds of services that surveyors provide that don't have anything to do with boundaries and plats. Here's some non-plat examples. Here on the left is a setback verification form that my firm prepared for the property owner at this location. It's got a little sketch of the property. It's got distances to the property line. Does not describe and depict. It just depicts property lines. And we've located a concrete foundation and provided the distances both graphically and in these in these lines right here. The certification, which we talked about, says, I certify that the dimensions stated hereon are accurate and based on actual field measurements. Surveyor seal, surveyor signature, and date. Poof. Then we have one of the FAA certifications. So this is what the FAA requires before they'll let the Federal Communications Commission, the FCC, commission a new cell tower is a 1A survey. And it just has these boxes to fill out. Is it on the ground survey? Is it a GPS survey? Is it based on NAD 83 or NAD 27? How did you get your vertical data? It's also by GPS. It's NABD 88. What is the structure type? It's a new tower, an existing tower, a rooftop, a water tank, a smokestack. Depending on where you are, if you think about these huge smokestacks next to industries and power plants, those are hazards for airplanes. If they get above a certain elevation, they are required to get a FAA 1A certification. So here the surveyor has stated the latitude and longitude to the nearest 100th of a second and the ground elevation to the nearest foot above average mean sea level. And then this is the certification level. So I certify that the position is plus or minus 20 feet horizontally and 3 feet vertically. Blah, 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 surveyor seal, surveyor signature, surveyor date. So these are non-plat examples. And this is an elevation certificate. This is another one prepared by my firm. These are the first 2 pages. There are 6 or more pages to an elevation certificate. The last pages require color photographs taken of the 4 sides of the structure. So here, we looked at the flood profile, which is the proper procedure for getting a base flood elevation, not just looking at the firm map like a lot of people do. You have to look at the flood profile, the FIS profile, checked right down here. If you check the firm, that's a red flag. They may get after you. That's not proper procedure. We've stated what the BFE is, the base flood elevation. And then relevant to this particular structure, we've got data up here. The building use is a residence. It's not a storage building, restaurant, etc. Here's the latitude and longitude. It's based on NAD 83 in this case. There are diagram numbers. You have to decide which building diagram is applicable to this building. The square footage of the crawl space or enclosure, how many flood vents, blah, blah, blah. Technical data that's provided over here is the elevation. There are A, B, C, D, E, F, G, and H that's required to either be NA or provided the elevation in feet, which is all related down here to the elevation, the base flood elevation. And again, surveyor's seal, signature, and date. This is where it's certified right here. Section D, this is of the official FEMA form, surveyor, engineer, or architect certification. So that's telling you that as far as FEMA is concerned, an engineer, an architect, or a surveyor can sign this, but not average Joe Schmo. You have to have one of those 3 licenses and affix the seal right here in this little box. So that's just another example of a non-surveying work product. We're coming back now to the special category of the hydrology and design authorized. This is the section in the law that says this is what surveyors can do if they have the HDA designation. Now, that HDA or hydrology and design authorized designation came from either being grandfathered by being licensed prior to 2018, or when the hydrology test was required, by the way, or by opting to take the hydrology coursework and exam after 2018. So this includes erosion and sediment control plans, including detention ponds. And there are some strings on the detention ponds. Surveyors cannot design high hazard dams or recreational lakes, just small impoundments for erosion and stormwater management that meet these criteria. Rule number 3, stormwater management plans and facilities, including hydrologic studies, temporary sediment basins, provided that the contributing drainage area shall not be larger than 100 acres. So there again, if it's draining over 100 acres, you probably have some floodplain, you probably have some loss of life. That's where the legislature drew the line on where they felt like a surveyor or a non-engineer, for that matter, could design something and where it became a public safety hazard. And little number 4 here, IV, extension of existing water distribution piping and gravity water sewers. provided that the offsite length does not exceed 1,000 feet. Maybe a little arbitrary, but if you're designing a subdivision that's 990 feet from the water main, you can design the water line and the sewer line in that subdivision, as long as the offsite extension is less than 1,000 feet. I guess they determined that if it's more than 1,000 feet, it must be some sort of municipal engineering project. But it does say that the water and sewer lines have to conform to local government ordinances and be subject to the review and approval of the Georgia EPD, who reviews water line plans and sewer plans all over the state. Anyway, so that's the this is right out of the state law. This is the legal definition for hydrology and design authorized services. And then here are some examples. Residential site plans, those do not have to be hydrology and design authorized, because the law says, in little number I, grading and site plans. So some of this is not restricted to hydrology and design authorized, but it depends on what all you're doing. If it includes erosion, sediment, pollution control, then that is in the hydrology. That is in little number 2. And also, see the asterisks, if you're issuing erosion, sedimentation, and pollution control plans, a land surveyor must also go through the training and certification through the Georgia Soil and Water Conservation Commission, GSWCC, as a level 2 design professional. So that's also required. And they give you this little card, like here's mine. And it expires every few years. You have to be recertified and so forth. But the rest of this pretty much is in the hydrology and design authorization, except for possibly this number 7, subdivision preliminary plat plans. That's probably included in the first part of that legal definition, but 4, 5, and 6, water, sewer, and stormwater, that falls under hydrology and design authorized. So if you don't have that designation, land surveyor can't be doing those services. So I hope this overview has given you something to think about, a broader understanding of the legal aspects of what land surveyors do, what they can do, and what they should not do. That's the purpose of this module. Again, the detailed goings in and goings out of plat standards and alpha standards was not covered. That will be covered in Surveying 4475. Thank you.